Hi everyone, good evening. I'm Neha Singh. I'm registered migration agent with Aussizz Group. I had been working with Aussizz since 2019. I'm located in Aussizz Werribee branch of Victoria. So if you have any questions related to the partner visa, which we are going to discuss today, you can just contact your nearest office, or if you want to contact me, you can just contact me on the given numbers, or you can just shoot an email to me on my email ID, which is there on the screen. So, so before we start, I just like to tell you about the Aussizz Group. So Aussizz Group has been serving to their clients for immigration and education services. They have been providing immigration and education consultancy and services to the clients since 2009. We have over 35, more than 35 migration agents and more than 70 education consultants with Aussizz, who provide education and immigration services to the clients. And if you have any questions, you can just contact the nearest branches, as we have roughly 18 to 19 branches all over Australia. So whatever is nearest according to your location, you can just contact the nearest branch of Aussizz if you have any certain questions to, or you want clarification on your scenario. So before we start, I would just like to say that Aussizz had these products. Aussizz, apart from immigration and education services, Aussizz do deal in PT. They provide IELTS tutoring. And if you want to buy your insurance, whether it's an OSHC or OVHC, you can just contact us, and or you can just visit the Get My Policy online to get the policy codes for different providers. We do provide NATI and CCL tutoring. Aussizz also provides services like professional ear and other PT and IELTS coaching also. So now, before we start, I would just like to tell you about a new app. It's Occupation Search. You can just download this app on your Apple Store or Google Play. This Auss Search is a mobile app that helps you explore your visa options, your state nomination criteria, your eligibilities, and your estimated visa fees. So you do not need to surf anywhere. This is the single app where you can find all the information about your ENSCO course, what are your eligibility criteria according to your occupation, and what are the requirements for different states for your occupation. So if you want to, explore your options, you can just download this app, and it's a one-go place to search all your options for your occupation. So now, today we are going to discuss the partner visa. So partner visa have different subclasses. It can be onshore partner visa, it can be offshore partner visa, as well as there is a prospective marriage visa, which is subclass 300. So for the offshore partner visa, we have 309 and subclass 100 visas. For the onshore partner visa, we have 820 and 801 visa. And for the prospective marriage visa, which is also sometimes called as fiancé visa, it is subclass 300 visa. So now, before we start, I would just like to tell you who can apply for a partner visa. So if you are looking to apply for a partner visa, you have to make sure that you are the applicant have a partner, or they are engaged, they are married, or in a de facto relationship with an Australian citizen, permanent resident, or an eligible New Zealand citizen. So it means that if your partner, who is an Australian citizen or a PR holder or an eligible New Zealand citizen, you are eligible to apply for the partner visa. So Australian citizen and PR holders, who hold the Australian citizenship or PR for Australia. Eligible New Zealand citizens are those who are New Zealand citizens and came to Australia on a special category visa, subclass 444. And they had been in Australia on 26th of February 2001. or those who had been in Australia for at least 365 days from 26th of February 1999 to 25th of February 2021, but who came after that date, they are also eligible New Zealand citizens. All other New Zealand citizens who hold 444 visas are not eligible New Zealand citizens. So if your sponsor, if your partner is an eligible New Zealand citizen, you can apply for the partner visa. But if they are not an eligible New Zealand citizen, you have to see if they can apply for the PR or they can apply for the New Zealand Australian citizenship. As you know, Australia has now announced that the New Zealand citizen passport holders who are in Australia on a special category visa subclass 444, they can apply for their citizenship after meeting the requirements of citizenship from 1st of July 2023 onwards. If they have applied for their citizenship and has been granted, then being a partner of them, you can apply for your partner visa. But if you are on a 461 visa, then you have to wait for your partner to get the citizenship for Australia, and after that you can apply for your partner visa. So now, after coming to this thing, first we'll discuss the onshore partner visa, which is subclass 820 and 801. So for the onshore partner visa, the first subclass, because this partner visa is divided into two stages. The first stage is the temporary provisional stage for the partner visa, and the second stage is the permanent visa for the partner visa. So for the onshore partner visa, the first stage is subclass 820, which is a provisional visa. At the time of grant, you have to see that you have a sponsor who is an Australian citizen, PR holder, or an eligible New Zealand citizen. And if you are meeting these criteria, you have to show that you have a genuine relationship with your partner, which we will discuss later on. If you are meeting all these criteria, you will apply for the partner visa from onshore if you are holding any other substantive visa. For example, if you are on a student visa or you are on a 485 visa and you have a partner who is eligible sponsor for you to sponsor for the partner visa, you can go for 820 visa. Once you lodge this visa, you will get a bridging associated with that, bridging A associated with that, which will allow you to stay in Australia indefinitely till some decision is made on your application for 820 visa. As well as during that stay, you will have all the travel rights, all the work rights, all the study rights. But if you have to, during the processing of the 820 visa, if you have to travel outside of Australia, then you cannot travel on a bridging A. You have to apply for a bridging B visa, and then you can travel and come back to Australia. So now during the processing time, because right now the processing time for 820 visa is 3 months to 9 months, during that processing time, you can stay. Once the visa has been granted to you, after that, you are eligible to apply for the next stage, which is the stage 2 for the permanent partner visa, which is 801, after 2 years from the date of lodgement of your 820 application. So you have to keep in mind, you will be eligible for 801 visa after 2 years from the date of application lodgement. So sometimes the department might grant you 820 and 801 all together, depending upon certain criteria. If not, then you have to lodge your next stage for the partner visa after 2 years from the date of lodgement of your partner visa. So now when we look into this partner visa application onshore, we have to prove that your relationship with your sponsor, your partner, is a genuine relationship. So how we prove the relationship is, there are different relationship. You can show that you are in a married relationship with your partner, or you are in a de facto relationship. So to prove the relationship, there are three options. Option number 1 is that you have a de facto relationship. Option number 2 is you have a registered relationship with the relevant authority of the state. And the option number 3 is your legal marriage certificate. So in option number 1, which is de facto relationship, you have to prove that you had been in a genuine and continuous relationship with your partner who is an eligible New Zealand citizen or a PR holder or an Australian citizen from the last 12 months. So this requirement of living together from the last 12 months has to be met at the time of application for 820 visa. If in case you do not have that requirement of 12 months living together with your sponsor, then it's not a worry. You can still apply for your partner visa 820 application from onshore. But in that case, it is always advisable that you should get your relationship registered from the authority, relevant authority. Like in Victoria, we have birth, death, marriages, and in other states, we would be having similar authorities which would be registering your relationship. So you can get your relationship registration certificate from the authority, which will prove your relationship. And this certificate, even if you apply for the partner visa and your relationship is not more than 12 months or it is less than 12 months, you can still apply and you can just provide the department with that registered relationship certificate anytime after lodging the application. The third option is that you are legally married. In that case, you would be having your marriage registration certificate from your country or from the state wherever you got married. So you have to provide that your relationship is genuine by providing any of these options for you. So next, coming to that your relationship. Now, when we go for a partner visa, so the department looks that your relationship is very genuine and continuing. Genuine means at the time of application, you would provide either your marriage registration certificate or you'll provide evidence of being in relationship from the last 12 months or your de facto relationship certificate. This proves your genuineness, but we have to prove the relationship to the department that our relationship is continuing also. So we to prove that your relationship is genuine and continuing, you have to provide you have to see certain aspects of your relationship, which would be first is your social awareness of your relationship. Second is your financial commitment. Third is living arrangements, and fourth is the mutual commitments. So social awareness of your relationship means that you as a couple, either it's a de facto relationship or as a married couple, people know about your relationship, that you are in a relationship. So to prove the awareness, social awareness of your relationship, there are a number of documents which you can provide to the department to prove that thing. The most common of that is the photographs for you, both together, couples together with families and friends. You have to provide form 888 from any of the 2 PR citizens who know both of you as a couple or as a de facto couple. They should be PR or citizen. They have to provide that documents with their being evidence of being PR or citizen of Australia. Apart from this, you can provide other invitations, like if you got a invitation from someone for attending a party as a couple with on joint name, you can provide those documents as well. You can provide your Facebook, like social media post that you publish yourself to people know that you are a couple or a de facto couple. Second is your financial commitment to each other. So when you are in a de facto relationship or as a married you are legally married to each other, you have to provide your financial commitments to each other as well. So financial commitment can be in the form of any joint bank statements. If you have a joint account and you are doing the transactions, you're buying any joint assets, or you're buying some lands for yourself on your joint name, that proves your financial commitments to each other. Other evidence what you can provide for your financial commitments to the department for this application can be, you can just nominate your partner as your nominee in your super as well. And if you are buying some assets on your joint name, that can prove your relationship and financial commitments to each other. The third aspect of your relationship is living arrangements. So living arrangements is like if you are living together. So how do you share your responsibilities while you're living together? It can be in the form of, arranging for your bills, utility bills, how you are sharing that, how you are, arranging your household codes. For that, you can just write a relationship statement, or you can give a statutory declaration from both the sides, applicant as well as the sponsor, that you have these much living arrangements, how your household codes are looked after by both of you, what plans you have for future. So you can just give all these evidence, and you can just provide your utility bills, like few of the bills are given by one partner and the few are looked after by the other partner. If you have child from your relationship, you can say that how will you look after the child, how you take care of the child. So how you're sharing your household duties with each other. The last aspect is your mutual commitments. So mutual commitments is like what are your future plans, and how you are committed to each other, what you will be doing in your future, how you're looking after each other. There are so many documents which you can provide. You can write down a relationship statement stating all those aspects for yourself, plus you have to provide evidence for all these documents. One thing is, for the relationship genuineness, we do provide documents at the time of application, but till the application is not decided upon by the department, you have to show that your relationship is continuing. So it's always advisable that you keep on updating the department with your relationship documents continuously over the time of period till the visa is not granted. So it is advisable for 820 as well as for the second stage of the partner visa, which is 801. So now these are the aspects which we have discussed for the partner visa to be granted. So once the partner visa, the stage 1, which is 820, has been granted, what the applicant can do? So applicant can travel from and to India, and they have full work rights. They have full study rights, as well as they can attend up to 510 hours of free English language classes, so that they can develop, if they need, their English abilities to work out. Now, the permanent stage for the partner visa, which is the next stage, as I told you earlier, once your 820 has been granted, and then you can apply for your next stage, which is the permanent stage for the 801 visa. After 2 years from the date of application, those 2 years are counted from the date of application. But in the next stage, which is the permanent stage for your partner visa, you have to provide the same documents that you are married or you are in a de facto relationship. Your relationship is still continuing and is genuine. You are committed to a shared life, excluding all other people. You will need to tell the department of if there is some changes, like you have changed your residential or marital status. Like before you were in a de facto relationship and later you got married, you have to tell the department about that. If you have got a child from the relationship, you should update this to the department as well. So department would be looking at the time of the second stage grant also, that your relationship is genuine and it is continuing. So you have to provide all the documents for your relationship to be genuine and continuing in the same way as you have provided for the 820 visa application. So now coming to the now you have to tell the department, like because it's been 2 years from the date of 820 application, you have to tell the department that there is no change, or if there is some change in your relationship, you have to update to the department as well. If your relationship has ended, or there is some kind of domestic violence going on with your partner, then you have to update the department in certain circumstances that the second stage of the permanent visa would be granted to you, depending upon certain circumstances. So now there are some new reforms to the partner visa. When we lost the partner visa, the 820 visa, there is no English language requirement, but these are the future reforms which might be introduced by the department, which are in process, but they have not been introduced at present. So we don't need to worry about that thing. The department would be implementing the English language requirements in future, but not yet. So we do not need to worry about those things. And the other reform which the department might introduce in future is that they want the application for the sponsor to be approved before we launch the partner visa. This, as we launch the partner visa, there is another application which is lodged after the partner visa has been lodged, which is from the sponsor. At present, we lodge it after. It can be lodged anytime after the partner visa has been lodged. And there is no such thing that we have to get the sponsorship approved before lodging the partner visa. But this is just a reform which is about, it is proposed, not yet implemented. So we do not need to worry about this thing. So now coming to this flow chart of partner visa, as I told you, there are different, offshore, onshore, and prospective marriage partner visas. So if you are looking for a partner visa, there are different prospects. Like if your partner is offshore, not in Australia, and you are engaged or you have a relationship with the applicant, you can first go for a prospective marriage visa, which is subclass 300. In that case, the applicant needs to be offshore, and it would be granted offshore. The prospective marriage visa would be granted to you for 9 months only. And once the applicant comes here on that visa, they have to get married to the sponsor within those 9 months, and then they have to lodge their 820 visa application and leading to 801. And if, say, your partner is overseas, not in Australia, there are different pathways for them to apply for the partner visa. Either they can come to Australia on a visitor visa. If they come to Australia on a visitor visa and do not have a no further stay condition on their visa, they can apply for the 820 visa, which is onshore provisional visa for the partner from onshore. And then later on, after 2 years from the date of application, they can launch their next stage, which is 801 visa. Or if their visitor visa do have the no further stay condition, then they are not eligible to apply for any visa from onshore. In that case, they can go for the 309 visa, which is an offshore partner visa. They have to lodge their visa, which will take like 5 months to 96 months is the processing time currently for the 309 visa. Once the visa is granted, they can come to Australia, and then they can apply for the next stage, which is the permanent partner visa, subclass 100 from Australia, and then they can proceed for their further things. So these are the options what you can apply for the partner visa. So now we'll discuss the prospective marriage visa, which is subclass 300. So for the prospective marriage visa, the applicants who are not married and they are overseas, but you are engaged and you want to bring your partner here to get married here in Australia, you can go for this visa as well. It is also called as fiancé visa, subclass 300. In this visa, you have to show that you have met the applicant in person, means face to face. You have the intentions to get married to that person. So you have to provide that your relationship is genuine and continuing. Because your applicant is overseas and the sponsor is in Australia, you have to show your genuine and continuing relationship in terms of evidence, providing your photographs together, your chat history, message history, how you maintain your long distance relationship, like talking to each other over the phone or over the message. Every day you have to provide evidence that you are genuine and your relationship is genuine and continuing, and you have intentions to get married to each other. So once this visa is granted to you, this would be granted to you for 9 months. And once the applicant comes to Australia on the prospective marriage 300 visa, They have to marry their sponsor, their partner, within those 9 months. And after that, they can apply for their 820 visa, which is the partner onshore visa, provisional one. And then later on, they can apply for their 801 visa as well after 2 years from the date of application of their 820 application. One thing we have to keep in mind, while applying for the prospective marriage visa, we have to provide our notice of intention to get married, that we have intentions to get married on this date. So you have to provide documents. You can just get your dates registered for marriage with any celebrant in Australia. You have to provide those documents as well for the prospective marriage visa. After that, now I want to discuss the partner visa, which is from offshore. So offshore partner visa, which is subclass 309 leading to 100, subclass 100. So in case, as I told you in the chart, if your partner, the applicant is not able to come to Australia on any visa, or they have no further stay condition on their visa, so they can apply for their partner visa if you are married or you have been in a de facto relationship. They can apply for their provisional visa from offshore as well, which is subclass 309. At the time of application, you should be outside of Australia, and at the time of grant, also the applicant should be outside of Australia. So in this case also, you have to provide your proof that your relationship is genuine and continuing. For that, you have to provide the relationship documents. Like if you are married, you will provide a marriage registration certificate or a de facto relationship certificate, apart from other documents as well, which to prove your genuine and continuous relationship. Once the 309 visa has been granted, then you are eligible to apply for your next stage, which is the stage 2 permanent partner offshore visa, which is subclass 100 from 2 years from the date of application for 309 visa. So now for the partner visa offshore also, as I told you, you have to provide that the evidence that your relationship is genuine, continuous relationship. You have to provide evidence for your social as the 4 aspects for your relationship, which are social awareness of your relationship, financial commitment, evidence of contact and communication, and mutual commitments. So for the social awareness of your relationship, you'll provide your photographs together with families and friends. You have to provide a 2 888 forms from any PR citizen who know you both as a couple, and they are happy to provide you, the department, with the information about your genuine and continuing relationship. In terms of financial commitments, like because your partner, your applicant is overseas, there could not be any financial, commitments, like because they are not present in Australia physically. You can provide documents like sending money to them, or they are sending something to you. You can provide evidence of any kind of goods, any kind of gifts you have sent to them, the receipts for that, or if they have sent something to you, you can provide that as well in terms of financial commitments. And in terms of evidence of contact of communication, because you in this case the applicant is overseas and the sponsor is in Australia, you are maintaining a relationship which is a distance relationship. So you have to show that though you are apart from each other, you are still maintaining your relationship by communicating and contacting each other over the phone or messages or any other social media. So you can provide your call, chat, message history, call logs to the department to just convince them that you're still maintaining and communicating with each other, and you're maintaining your long distance relationship. So mutual commitments can be in terms of your household, what are your future plans, and what you understand, and your partner wants to come here and you want to share, and you live life together. So there are so many documents which you can provide for the partner visa. You can write down a relationship stating that how you met each other, how you went into a relationship, and what are your social aspects, financial commitments to each other, what are your household chores, and what are your future plans, you can just write down to just state the department that you are maintaining a genuine and continuing relationship with each other. So once the partner visa has, the offshore partner visa 309 is granted, then you, for the grant of this visa, you have to meet other requirements as well, your health requirements and character requirements. So in this case, you have to go for medical for the visa to be granted, and character requirements. They might ask you for the police clearance, police verification from your home country or other countries where you have lived in for 12 months in the last 10 years. So these are the other requirements which you have to meet for the grant of your partner visa. So one thing I just want to discuss is like there are certain restrictions to the sponsorship for the partner visa. So if your sponsor had been married before and now they have legally divorced the previous partner, they sponsored them for the partner visa previously, then they have a restriction that they cannot sponsor you for the partner visa for the 5 years from the that 5 years starts from the date the partner visa application was lodged, and the sponsor has a limit to sponsor only 2 people in their lifetime. So one thing you have to keep in mind, sponsorship has certain limitations for the partner visa. You can sponsor someone twice in your lifetime, and there should be a difference of 5 years that from the date of application. Say, for example, you were sponsored by someone for the partner visa, then and after your PR has been granted, your 820 or 801 or 100 has been granted, you are divorced, you are separated, then you can sponsor the next applicant, your next partner, only after 5 years from the date of application your partner visa application was lodged. This is one of the limitation, I would say limitation on the sponsorship for the partner visa you have to keep in mind. If any of the partner has been in relationship with someone before, they were legally married or in de facto relationship, if they were married, then they have to show that they have legally divorced from their previous partner. You have to provide these documents as well at the time of application to show that you are not anymore in relationship with your previous partner. So now coming to documentation, when we lodge the application for the partner visa, there are some mandatory documents. As I told you, to prove their genuine relationship, you might be either you should be in 12 months relationship, or if your relationship is not more than 12 months, you can get a de facto relationship certificate from the relevant authority of your state, or you should have a marriage registration certificate. Apart from this, we do require 2 888 forms from any Australian PR or citizens who would provide the department with the information that your relationship according to them is a genuine and continuing relationship. These are some of the few documents. Apart from this, you have to provide a number of other documents to prove your social commitments, your financial commitments, your mutual commitments, and your household commitments, how you share your households. You to provide these. It's not that you have to provide one time the documents. You have to keep on providing the documents to the department on a regular basis, like after every 1 month or after every 15 days, you should submit few documents to prove that your relationship is genuine and continuing till your 801 visa is not granted to you. So these are the few things which we have to keep in mind while lodging an application for a partner visa. So we are done with this thing. If you have any questions, we can just you can just leave a comment and we can answer you about the partner visa if you have any questions. Or if you have any specific case, you can just contact us anytime to the nearest branch of Aussizz, and we can just help you out to clarify your questions. So we have got a question from Simran. Hi, my fiance is on subclass 500 student visa. Can we apply for a partner visa? If yes, how long does it take to get a partner visa? So Simran, the partner visa which we have discussed at present, they are for the partner visas. If the sponsor is holding PR or Australian citizenship, or they are eligible New Zealand citizen. If your fiance is on 500 visa, then you have to apply for the partner's subsequent entrant as a partner for them if you are a sponsor to fiance. So that is not a partner visa, that would be a subsequent student subsequent visa. You can apply for that visa also. It is taking not that takes to get a partner visa. It would not be a partner visa but a dependent visa, student dependent visa. You in that case also you have to prove that you are genuinely in relationship with the student, the applicant, and you have to provide your relationship document as well. Apart from them, there are certain documents like your genuine temporary criteria, your financials also to provide for the student dependent visa. At present, it is taking from offshore 3 to 4 months, but yes, your relationship should be genuine. Now, there is a question from Mahesh. Are there any common reasons why partner visa applications get rejected, and how can these issues be avoided? So, Mahesh, when we talk about the partner visa, the department needs to see that your relationship is genuine and continuing. Genuine we can provide in terms of your marriage registration certificate, or you can provide a de facto relationship certificate. But if you are not able to prove to the department that your relationship is not continuing till your 801 or subclass 100 is not granted, they can refuse you a visa also. If say there are some domestic violence going on and your 820 has been granted to you, there are certain criteria in which you have to prove that you are being, a sufferer of domestic violence. They might grant you the next stage of the partner visa, but we need to look into the reasons why it has been rejected. So we need to avoid those issues like the first thing is your relationship should be genuine, and you should be having a continuous relationship. You should be living together. You should have all your mutual ties and your financial ties, social aspects. As we have discussed, these are the issues. If the department feels these are some of the aspects not covered by the applicant while lodging, and they are not able to provide the evidence for their continuing relationship, they might refuse you a visa for the partner visa. We got a question from Faisal. What is the processing time for partner visa application, and are there any ways to expedite the process? So Faisal, at present, the processing time for the partner visa, which is the stage 1, for subclass 100, it is 15 months to 23 months going on. For the 309, which is offshore partner provisional visa, 5 months to 96 months has been updated by the department, though this is just a processing time, but they have to decide the application before two years, because if they take more than 2 years to decide upon the 309, they have to grant you the subclass 100 as well. Now, we got a question from Suhani. What are the options for appealing a partner visa rejection and addressing a visa cancellation? So, appealing a partner visa rejection. So Javi, we need to see what are your criteria going on, why your partner visa has been, if your partner visa has been rejected, on what grounds it has been rejected. You can go for MRT, AAT, and you can fight for that. If not, then you can look for some other options for you. We got a question from Teddy. Currently on bridging visa A of student visa, can apply partner visa on bridging visa A of the student. Do we need compelling reasons due to bridging visa A of student? What visa will be while on bridging visa A of student visa? So Teddy, I'm not able to understand what you want to ask. You are just asking if you are on a student, if you have applied for a student visa and you are on a bridging visa A, you cannot apply for a partner visa on a bridging visa A. To apply for an onshore partner visa, which is subclass 820, you need to be on a substantive visa. On a bridging A or B, you cannot apply for a partner visa. If, say, there are some compelling reasons because of which you have to apply for the partner visa, in that case, you have to meet the Schedule 3 criteria for the partner visa, and you have to show that there are some compelling and compassionate reasons because of which you have to apply for the partner visa from onshore. So I think we are not... So at present, the processing time for the partner visa is it has been updated by the department. As I would just like to give an idea about the processing time for different partner visas. For subclass 309, the processing time by the department is 5 months to 96 months at present. For the subclass 100, it is 15 months to 23 months. And for the subclass 820, which is onshore provisional partner visa, it is 3 months to 9 months going on. And for the subclass 801, it is 13 months to 15 months going on. So, and at present, the department fees has been increased for the partner visa. At present, it is either it is subclass 309 or 820 or the prospective marriage visa. The processing fees for the department for the partner visa is 8,850, which was earlier $8,050 last year, but this year it has been increased to 8,850. So I think we are not having any questions. If you have any questions, any doubts, you can just contact us on the given numbers or the nearest branch for Aussizz. So all good. Thank you.